Welcome, everyone. That's great to have you all here at the 4IP Council's webinar, which is called Generative AI on Trial. Do models themselves infringe copyright? My name is Axel Farazzini. I'm the Managing Director of 4IP Council, and I'll be your host today. As you may know, 4IP Council is a not-for-profit research organization, and we are focused on the link between IP and innovation. Our mission is to identify the most relevant topics and produce empirical research by collaborating with a variety of academics, experts, IP organizations, and other stakeholders. On our website, you can find plenty of free materials. For example, summaries of relevant papers, guides, and studies. We also upload the recordings of our webinars, like the one we are doing today. And we have a podcast called IP Stories, where we interview inventors, entrepreneurs, and IP disseminators. We also produce easy to digest content such as the SMEs Corner, especially tailored for non-IP experts, SMEs, and startups. I'd like to also invite you to the area on our website called IoT and Cellular Standards Made Simple, where you can learn about the benefits of standards and IoT across different sectors. We have launched a new area called AI and intellectual property rights with guides, videos, papers, and interviews to help you understand how AI is revolutionizing the way we live, work, and create, but also the pressing questions raising about intellectual property rights. But without further delay, it is really my pleasure to welcome our speaker today, who is Professor Noam Shemtov. Professor Noam Shemtov joined the Center for Commercial Law Studies at Queen Mary University of London in September 2009. He holds the chair of Intellectual Property and Technology Law at CCLS and serves as director of the Queen Mary Intellectual Property Research Institute. He teaches across the fields of intellectual property, creative industries, and technology law, which also form the core focus of his research. He currently serves as president of the European Intellectual Property Institutes Network, EIPIN, and he has recently launched an exciting new module, Intellectual Property in the AI Era, as part of the program bringing cutting-edge legal debates on AI, innovation, and creativity into the classroom. We are delighted to have him with us today to discuss some of the most important questions shaping copyright law in Europe in light of recent judicial developments. A final remark for the audience: please do not hesitate to use the Q&A tool that you can find at the bottom of your screen to submit your questions. You can find it again at the lower part of the screen, so please do not hesitate to use it. You can raise your question anytime, and right after the presentation of Noam, we will take yours. Noam, the floor is yours.
Thank you, Axel. Thank you for the opportunity to speak to our audience on this exciting topic. So let me just launch my presentation, and we're fine. So what I intend to discuss, to unpack today is the question, I wouldn't say the emerging question, but becoming more and more relevant in light of a number of things that I will point to during my brief presentation. It's memorization in AI models, and what are the copyright implications of it. We had a couple of decisions lately where this was at the forefront of the discussion. So what I intend to do today is, first of all, to explain a little bit about memorization. What is it? And what kind of how may we characterize memorization in light of very recent research, not legal research, research which is embedded in computer science. Then we will move on and discuss the two decisions that I referred to earlier, Gamma and Getty Images. And then we'll end up with asking whether and to what extent we may characterize memorization within an AI model as reproduction, infringing reproductions, and what are the repercussions of that to copyright law and perhaps to the AI industries, creative industries, and so on. So, let me just... So what does memorization look like in practice? Now, there are concrete examples to memorization across both text and image models. Research, and quite recent research, has demonstrated that leading language models could reproduce near complete copyright books when prompted strategically, and the same behavior could be observed also in image generation systems. So image models trained on large data sets have been shown to output images that closely resemble specific training images. So memorization exists. Memorization is there both in relation to text generation and image generation. So how do models memorize? Without going, I think the audience would appreciate, without delving too deep into the actual, under the hood, into the actual technological realities within LLMs or large language models. I think what we can say is, a term that is often used is lossy compression. Effectively, rather than storing training data as discrete files, what model appeared to do is to encode statistical relationship between tokens and image features. This is sometimes could be referred to as lossy compression. Now, lossy compression does not mean that the information disappears, neither does it mean that the information about various aspects of the content on which the model was trained is floating aimlessly within a model. In what I think computer scientists would refer to in sufficiently dense regions of probability space, models can reconstruct and do reconstruct original sequence with high fidelity. So the information stored, albeit stored as probabilistic data inside the model, is being stored there where the connection between the different aspects, either of the text or of the image, are being kept. So those connections are being kept, not perfectly always, quite often not perfectly, but there is sufficient connection, or there are sufficient connections so that reconstruction can take place in such a way that a version which is very close to origin could be or may be reconstructed. I mean, only recently, and then recently as of this January, we had researchers in Stanford and Yale that revealed, again, something quite interesting, perhaps not that surprising to those of us who deal or look at that area for quite some time. So they looked at 4 popular large language models: OpenAI, Anthropic Clouds, Gemini, and Grok. And they established they have stored large portions of some of the books they have trained on. So for example, when prompted, just one example, and then we move on, when prompted strategically by researchers, Cloud appeared to have delivered near complete text of Harry Potter and the Sorcerer's Stones, of The Great Gatsby, of 1984, and of Frankenstein. Similar behavior was observed in relation to the other model. So memorization is there. But what does that mean for our purposes? I mean, you would see that AI companies often refer to the learning metaphor, right? So they would say that AI does not store, but AI learns like in a similar fashion to human education. But I personally wonder to what extent this analogy actually holds. Now, humans do not store verbatim or close to verbatim copies of books that they read, nor can they reproduce entire novels on demand. And the same applies to images. Large language models can do that, and often do that when prompted strategically. And they can reproduce extensive copyright material. A very important point here is the last bullet point, and that is that this behavior is not accidental. It's not a bug. It is structural. It is a feature of an AI model being an AI model. So my personal view is that I'm treating a AI model's behavior by reference to a human learning, by analogy to human learning, should come with a very big sticker of handle with care. I think memorization raises two major copyright questions. First, if model output copyrighted works. So if a model generates copyright works, AI companies may be liable for reproduction and communication to the public. But this is not a huge surprise. This is something that I think most people would agree on, right? We also see that filtering mechanisms, output mechanisms that have been installed, and there have been a number of attempts to do so, can be circumvented quite easily by the right type of prompting. And again, my understanding is that does not require a lot of effort. But secondly, and more interesting for our purposes, memorization raises the possibility that the model itself, post-training, could be treated as an infringing copy. So if the model itself retained what under the law we consider to be reproduction within the meaning of copyright, then the model itself could be treated as an infringing copy, and that can have fairly significant repercussions as we will discuss in a few minutes. Now, this is memorization. We describe what memorization is in a nutshell. Let's have a quick look at how this phenomenon of memorization has been treated by the courts rather recently. And the first case that I would start with, and I think requires a little introduction, is the recent Gemma versus OpenAI decision. The issue here was the memorization of songs. Gemma is the German collecting societies for authors and composers. They brought an action against OpenAI on that ground. The court focused in this decision on the question of memorization. Now, Gemma itself argued that the lyrics have been memorized within the model, but that did not constitute an infringing copy. The court disagreed. The court looked at the level of reproduction. The court looked at the specificity of reproduction and the quality of reproduction, and concluded, quite rightly in my view, that this is not accidental. This is clearly based on the fact that those songs were used to train those models. Does that mean that those models constitute in themselves an infringing copy? And according to the court, the answer was yes. The court accepted that memorization has occurred, and the court held that memorization satisfied what under German law is referred to as the embodiment requirement for reproduction, so fixation. The lyrics were reproducibly defined within the model's parameters. Whether you whether it is stored as distinct files or not, according to the court, this was less relevant. Information that captures the expressive value of those works was stored as probabilistic data, but in such a way that it could be reproduced either verbatim or close to verbatim. And according to the court, that was sufficient for the court to hold that an infringing copy was retained within the model. So the model parameters constituted the embodiment, and the fact that information about those copyrighted works was captured and retained within the model was sufficient for it to constitute a copy. The fact that it's an AI company has put forward this argument in a variety of contexts that you don't have a file, say whether it's an image file or a text file or a sound or an audio file stored as a distinct file within the model in the more traditional manner in which we actually consider a copying. The court said that this was irrelevant. It was irrelevant that the information that captured the expressive value of the work was retained as probability-based data. Was information about the content existed within the model? Yes. Could that information be used in order to reconstruct the work? Yes. In that process, do we have the expressive value of the work being retained and then reconstructed? It's reproducible? Yes. If the answers to those questions, as I said, were yes, it was sufficient for it to be considered as a copy under EU copyright law. And that's exactly what the court concluded. And finally, when OpenAI tried to push on the question of responsibility, so who was actually liable for the copying that took place at the output stage, the court said that it was OpenAI and not the user that was responsible for the infringing outputs, because it was OpenAI that controlled the training data, controlled the model architecture, and therefore had the memorization risk. This case is often compared to and contrasted with Getty Images. I think that this again is useful only only to an extent, and I'll explain why. Now, in Getty Images versus Stability AI, the UK High Court found in favor, on most grounds, in favor of Stability AI, and importantly, perhaps for our purposes, the court found that the model itself was not an infringing copy. And I think on a number of occasions, I've seen people focusing on the bottom line and saying that was the right decision. Here, the court looked at this question and concluded that the model is not an infringing copy. But I believe that if we look carefully at the case itself, the case was actually held on different grounds. When expert evidence was produced before was submitted to the court, it appeared to be that both parties, both Getty and Stability AI, encouraged by the court to do so, accepted that the model itself did not store the infringing content within the model. And when you look at it, this question was resolved, but by looking at the question of copying copying in a digital environment in a rather traditional manner. There were not discrete files representing those training materials existing within the model. I think everyone would agree that is the case. The question is whether that is the only way in which one can actually conclude, or the only ground on the basis of which one may conclude whether there is or there isn't a copy within the meaning of copyright law, irrespective of whether it is a copy according to a computer science-based definition, A copy for the purposes of copyright law is a legal concept rather than as a computer science a concept. Of course, one is informed by the other, but it doesn't necessarily have to be the same, which to me seems to be what the Gamma court concluded. In this case, both parties accepted that that is the case, and therefore Getty conceded that no stored images existed inside the model or embedded within the weights of the model. This was not discussed. If you look, and the judgment is over 200 pages, you look at those 200 pages, there's a little discussion which is dedicated to that because, as I said, Getty considered that the images were not stored within the model. And therefore the case hinged on a somewhat different question, and that is whether the fact that perhaps the model was trained on the basis of infringing copies and was trained in a manner that constituted infringement in another jurisdiction meant that the content itself, the model itself, was now tainted by that infringement, and therefore the model itself could be considered as an infringing copy when it is available in the United Kingdom. And the answer, again, not surprisingly, to that was no. So no model as an infringing copy in that context. But I want to stress the point again that there was no in-depth, meaningful discussion as to whether a model is a copy in the same manner that took place in the Gamma context. So we need to bear that in mind, that there was no finding of memorization as an infringing copy, largely because Getty considered that that was the case, and therefore the infringement argument failed in the end. I would like now to finish very quickly with asking the following question. What counts as a copy under copyright law? And maybe if we try to frame this question and to look at it, take a step back and look at it a bit more realistically, it can help us reach our conclusion, own individual conclusion, as to whether the Gamma court got it right or not. Or perhaps how would such a decision be resolved in the United States? Now, there were a number of cases in the United States where those arguments were put forward, but again, to my mind, these were not pursued with vigor, and the essence of what does or does not constitute a copy perhaps could have been argued somewhat differently. Now, what counts as a copy? To me, when I look at EU jurisprudence or at US jurisprudence, it seems to be that capturing the expressive value in one and recording it in one way or another may count as a copy. So I put a question here, is it a reproduction to capture the expressive value in information that allows later reconstruction, even if that one is imperfect? And I think this is the key question here. And to my mind, the answer is, in many cases, affirmative. It would be reproduction to capture the expressive value in information that allows you to work it backwards. Even though the backwards or the reconstruction is not perfect. We know that reproduction does not equal perfect duplication. As long as I reproduce something, for example, in the EU, that reflects the author's own intellectual creation, it doesn't have to be perfect. That may amount to reproduction. Fixation and recoverability are key criteria for the essence of something being a copy, the concept of a copy. And therefore, whether the fixation takes place in encoding or compression, or in our case, probabilistic data is less relevant. Fixation and recoverability. Now, if you look at the United States, the law in the United States, you look at the definition provision under Section 101, and it's clear that the copy, for something to be a copy, it needs to be fixed, and it's absolutely fine if perception or perceptibility can take place only by using a machine, right? So this goes back to the old software cases that we had. There is no requirement for exact duplication. Imitation simulation rather than verbatim may infringe. Again, no surprise there. And the same goes for the European Union. A reproduction, direct or indirect, by any means and in any form. We know from InfoPack partial copy may be sufficient. The focus is on a copy or copying that captures the author's own intellectual creation. Again, it does not have to be perfect. So where does that leave us? I mean, in the United States, the question is still whether or not, if a court is prepared to accept that copies within the meaning of copyright law are retained within a model, then it gives rise to the next question. Is it then fair use? And again, we go to the question of fair use, and I think in this in this context, one of the more interesting questions that we have now is the question of the fair use and the four-factor of fair use, and whether market dilution type of harm would gain judicial acceptance under the fourth factor, and we don't have time to go into that. I think that when we look at the situation in Europe, we are asking ourselves to what extent the text and data mining provisions or exceptions would apply, would be applicable to a copy that is retained within a model. So first of all, we need to see whether the Gemma kind of analysis would actually gain traction. So Gemma is now on appeal, and I would not be surprised if at all if this question would be referred to the Court of Justice. So can we consider, as a matter of copyright law, AI model to contain or to retain copies, even though those copies may exist or may be stored, may be retained in the form of probabilistic data? But if the answer to that would be affirmative, then the next question is, okay, do we still have our Article 3, Article 4 type of structure applicable to these copies as well? Now, the Gemma court seemed to think that the answer is no. According to Gemma, those exceptions, the provisions, the TDM provisions, regulate the permissibility of preparatory acts of reproduction in text and data mining, in situation in which the exploitation interest of the authors are not jeopardized because mere information is extracted and the work as such is not being reproduced. But in the case of reproductions in the model itself, the exploitation of the work is permanent rather than temporary. It's permanent, and it's therefore permanently impairing the legitimate interests of the right holders, and therefore it is an infringement. In other words, Article 3 and Article 4 do not bite, so to speak, in the context of a model, a finding of a model as an infringing copy in itself. Now, if that is the case, we have quite an issue on our hand, because the public policy considerations that were involved, rightly or wrongly, right, or engaged rightly or wrongly in setting priorities according to Article 3 and Article 4 are becoming, the whole thing is becoming redundant. Actually, the question of whether or not a copyright infringement took place at the training stage is becoming much less important, if at all, if I'm holding that the model itself contained copies of the works on the basis of which it was trained. And if I'm then holding that none of the provisions of, so none of those exceptions of Article 3 and Article 4 do not hold, that can bring that can bring the whole system into a state of confusion and perhaps would require rather a quick intervention in setting priorities, and maybe that would actually give the legislator an opportunity to set priorities in a somewhat different way, because as we all know, Article 3 and Article 4 type of arrangement was subject to quite a lot of criticism. But again, we are just estimating here. I think for the UK, which is where I hail from, it perhaps gives an opportunity. Some of you may know that the UK government went out with a consultation last year, wide consultation on the question of AI and copyright, and the question of and it is deliberating those questions right now in light, among other things, of the responses that it got to its consultation and other steps that it has taken since then. Now, therefore, the UK exceptions are now at present in a state of work in progress, and the UK not being the first to jump the gun perhaps would give it an opportunity now to reconsider its position. And if it does decide that there are certain instances in which it wishes to excuse AI models or operators of AI models from infringement, those exceptions would be drafted in such a way that it would be clear that both the training activity, but also any copy that may be retained within a model post-training, would be excused to that extent. And I think that with that, we reached the end of our presentation. So I hope you enjoyed it, and any questions that you may have, please use the chat box. Thank you.
No, it was amazing. So I suggest that we'll start with a few high-level questions, and then we'll go into more detailed questions. And if at any point you have already covered the answer in your presentation, but I'm still asking the question, please feel free to let me know, because that will be faster. We have many questions. So the first one is, in your view, how should European copyright law distinguish between memorization, learning, and reproduction when analyzing outputs generated by LLMs?
Okay, I mean, that's an excellent question. To my mind, when I touched upon it a little bit, if I look at EU jurisprudence, and it seems to me to be the case that when I have fixation and recoverability from information that recorded aspects of the work in question, I have, or I may have, a copy within the copyright law sense. I personally do not think that the learning analogy is useful. I think it is, and a very high level of abstraction it may be. When we look at what is actually happening here, we see that also those models, as I said, the ability to churn out the example just from this January, as I said, the Stanford and Yale research that I referred to churn out entire volumes of tens of thousands of words, if not more. To call that learning as in a human, learning as in a human sense, I think it's unhelpful. I think we need to look at what is happening here. Information is being captured, is being retained, and then is enabling reconstruction, either verbatim or close to verbatim, or at the very least reconstruction where aspects of the author's own intellectual creation are being reproduced and therefore consisting of a copyright infringement in relation to this output. I think that is copying. The question is, how do we deal with it in Europe? If we do accept that it is a copy, and I think that there is a decent, if not strong, argument to say so, then what's the next stage? What should we excuse under these circumstances, and where does it leave the AI landscape as a result? Yep.
Very good. So this one is a bit long, so I will try to read it correctly. In light of these two recent decisions, what evidentiary threshold should be required to show that an AI system as reproduced protected expression rather than merely learned statistical patterns. Given the black box nature of the LLMs, what kind of technical evidence should courts require to establish memorization of copying, and who should bear the burden of proof?
Okay, so I think that's a brilliant question. When it comes to, so how do we show that? Again, I don't think we need to reinvent copyright. I mean, the burden of proof to prove that infringement took place rests with the claimant or the plaintiff. We know that. But we know that an inference of copying may be drawn from similarities and access. So, do we have similarities between the two works in question? And did the defendant have access to the plaintiff's work? For example, when the Gemma court looked at it, this is not incidental. This level of specificity in the similarity between the two works suggests that there was training taking place on those songs, meaning access was there. So if we had access and we have such a high level of similarity that cannot be explained by randomity or chance, there is an inference of copying. Of course, this is only an inference, and the way it works under copyright law, that at that point, the burden of proof shifts to the defendant in order to try and convince the court that regardless of the similarity, the defendant's work is a result of independent creation. I think a defendant may due to the black box aspect that you have described, may find that challenging. I have two works. One was a result of training on the basis of the other. That's going to be very tricky. So ultimately, if courts are going to follow the Gemma path or the Gemma school of thought, let's call it like that, I don't see a way in which, in a lot of those cases, the defendant would be able to convince the court that this is this similarity is not a result of copying within a copyright.
But if courts continue to treat memorization as potentially infringing, what are the broader implications for innovation, licensing markets, and the development of European AI models?
I think this is fascinating. I think that this is where we are. If that is the case, and if Article 3 and Article 4 so do not apply, so as you just said, it is infringement. That means that AI companies need to reach, and perhaps it would be difficult for them to do that on their own, but we need to find some kind of an arrangement where a license or blanket licenses can be sought, because most people would agree that we want to continue, at least most, I think. I haven't taken stock on that. That agree that we want to continue and encourage investment in AI and in AI technology, and want to continue and encourage those outputs of AI systems which are beneficial to society, that have social benefit. So we want to have a model, a business model that is workable. But if indeed a model would be treated as containing copies on all or some or most of the works on which it was trained, that means that the model would be infringing, and therefore you need to ask permission. But permission from whom and how? From what? From billions of items, perhaps, on the basis of which it was trained. So I think we do have, if that is the case, then we do have a problem at our hand, and we need to come up with some kind of a structure. And there are a number of scholars that out there that proposed various mechanisms in relation to either licensing or a remuneration in one way or another, right? So some kind of a platform tax or levy, or whichever way you may come at it, in such a way where you don't have to worry about right clearance, because the transaction costs would be enormous. AI companies would not be able to do that, to clear rights in relation to each and every work on which their model has been trained. But you do get either permission as part of a license, or the law mandates it in return to some kind of a compensation, which may, for example, come, as I said, as a levy.
Okay, now a question that is more technical details. I'm not sure you will have an answer. Which technical methods, if any, are currently known that could realistically trace whether a specific copyrighted work was used in training of an AI?
Right. So I know that there are a couple of websites there that are actually, I don't know which kind of technologies they use. And maybe it's not the technology at all. It's just freely available information about datasets and so on. But I think that what is interesting for our purposes is that I don't have to establish as a matter of fact that model A was trained on work B. As I explained before, the way copyright law works, is also on the basis of inference. So if I show a high degree of similarity between the two works, and this similarity is found by the court not likely to be the result of randomity or chance. And remember, this is a civil. These are civil cases, so it's the only thing that you need to show is more likely than not, balance of probabilities. If the level of similarity is such that it is more likely than not that one was trained to an extent on the basis of the other, as a matter of law, that may be sufficient, rather than to go and show as a matter of fact model A, and I have a forensic evidence that model A was trained on work B. The fact that model A churns out an output which is very similar to work B may be enough for the purposes of copyright law.
Oh, okay. So from a very practical question, what are the available defenses for businesses using AI tools? Is it enough for a business to have a contractual commitment that their business data will not be used for their AI tool training purposes?
So we are okay. So this is about me being a business using an AI tool and wondering to what extent the inputs that I am providing to the AI model would be used to train that model. Yeah, I think, I mean, it also depends in which sector you work. But there are various AI tools there, again, depending on the sector, that allow you, usually for a higher rate, right, license rate, to have the option or to opt out from having your input being used to train the model. So it's not a defense per se, but I think a lot of the things at present, to the best of my knowledge, are being governed contractually. I mean, even the general purpose AI model, such as ChatGPT, the one that is for fees, rather than the one that is available for free, I think. It gives you, if you go to the setting, it gives you those options. I know that, for example, if you look at the AI tools that are available in the legal industry, the legal sector, right? So I'm not going to mention names. It is very clear that the last thing that you want as a business is to provide inputs which may actually reflect trade secrets, your own trade secrets, what differentiates you from the competition. And if you provide those inputs or some of those documents into an AI models, and this is being fed into the model and then being offered as part of a service to your competitors, you're kind of standardized your own competitive advantage. And that doesn't make a lot of sense, I mean, from a business perspective. So what you would like to do under such circumstances is to look for a provider that enables you to opt out from that, and they may do that for additional fees. Now, what is your ability to actually audit that or to make sure that that's the case? Again, I think technologically this is very tricky. I think it's only in a case where you see outputs being churned out by such a model that resembles very much what you have fed into this model, but under this within this exclusionary mechanism where you ask for that not to be included in training, and nevertheless you see that it does come out. On the basis of that, perhaps you can make this inference that I was referring to before and ask for some answers. But this is, I agree, this is a rather tricky.
Okay, but do the Getty Images and the Gamma decisions suggest a shift toward focusing liability primarily on training stage conduct?
I think so.
Or on infringing outputs generated?
Yes, I think so. I think it's interesting because the beauty, so to speak, of focusing on training is that a lot of on the model as an infringing copy is that a lot of those questions which were considered to be quite tricky in the past are becoming less relevant. So, for example, people focused in the past on the question of where did training take place? People were referring or raising concern about training arbitrage. What if I am conducting the copyright relevant activity in jurisdictions that are very friendly to training as far as copyright law is concerned, for example, Japan, and then after training has been completed, I am offering the model post-training in my jurisdiction that have stricter conditions for training. For example, the EU. As I said before, the beauty of focusing on training is that this becomes less relevant. It doesn't matter where you train. It doesn't matter if you're excused in jurisdiction X or jurisdiction Y. The minute the model is being available and placed in the market in a particular jurisdiction, and the model itself is considered to have a copy retained within it, this is where copyright law of that particular jurisdiction becomes relevant, rather than by reference to where the actual training took place. So I'm not surprised to see content providers and right holders starting to focus more and more on the question of training due to that, because it simplifies things for them. Also due to this very recent research which is emerging in relation to memorization not being a bug, but being a feature of AI models and being available across the board, whether it's image, audio, or text. Yeah, I mean, that's something. I mean, about a year and a half ago, I wrote a paper with colleagues from the States where we actually floated this idea. So I touched upon this idea already then. Can we consider, and under which circumstances we may consider a model to be an infringing item in its own right? And if should that be the case, then it kind of take the order of things as we have them now, and to an extent at least stand it on its head. I can really see the advantages for right holders to go down this road. And should, as we said, should they be successful in convincing courts that that is indeed the case, and I think that they have a decent argument, at least in that respect, then things are definitely going to change.
A quick follow-up question. Why did Getty concede that the model did not store the copyrighted images? Was that because of a lack of evidence? I
think, I mean, I find it, I don't obviously have the ability to get into the head or the mindset of the legal team in Getty. I'm sure they had, you know, it's a highly qualified team, and they had their reasons. But I believe that sometimes when you look at a technological state of affairs, and you bring expert evidence, and you would bring computer scientists, right, with particular expertise in these fields, and you would look at the question of whether you have whether a copy was made. I think it's sometimes easy to get lost in the the technical explanations as to, for example, how that may not be a copy. And from a computer science perspective, and I'm not here to argue with that. Perhaps this is not considered to be a copy because it is not a discrete file per item, because it is spread across as probabilistic data, but while still maintaining connections, lossy connections, in relation to the different items within that particular, either in the case of Getty image or images. But ultimately, if a step or two steps backwards would have been taken, and the question would be, well, hang on for a minute, even though this may not be considered as a copy by computer scientists, the question that we need to ask is it a copy as far as copyright law is concerned? And to go to some of the basics that we have covered here and ask yourself, what do we mean by copy within the context of copyright law? And when we said that, when we asked this question, and we looked at it across the board, whether it's in the US or whether it is in the EU or in the UK, and we saw that what you need is fixation of information and recoverability of the work, either in full or in part, but as long as it captures the expressive value, or in the EU, we would say the author's own intellectual creation, that is sufficient, then I think that it becomes less relevant whether or not it is captured as probabilistic data or other type of data. And perhaps this is not something that was looked at in Getty, was perhaps also not encouraged by the court, and the court chose to focus on the more strict and traditional way of looking at copies. Up until now, and with the technologies that we had, yes, you encode the information in a discrete file and keep it as such, and that would enable you digitally to reconstruct the information with high fidelity. So, in other words, reconstruct it fully, but it doesn't have to be like that. And perhaps this is not something that was, I think it could have been explored in greater depth in Getty, and it hasn't.
So 2 questions now more related to the prompt. If in the end, it is concluded that certain LLMs were created on the assumption that the copyright works used were open access, should it be presumed that anything produced by these LLMs is also open access?
No. So the fact that I am making my work available, so let's say that I created a work of art and I have, and it is available on my website, and there is no paywall, people can come and look at it or view it. It does not necessarily mean that I am, it's free for all, that I have relinquished my copyright in that work. It is true that perhaps in some jurisdictions, maybe under contract law, you would be able to conclude that there is an implicit license by me, by having my work available for people to come to do and maybe even to copy. But I don't think you can build a business model on that basis, because in other jurisdiction, quite clearly, that would not be the assumption. An implicit license of that sort would not be inferred. So having open access is one thing, but taking this content and embedding it within the model, so that that model would be able afterwards to churn out outputs which resemble or maybe even identical to my original in endless numbers. So these two things are not the same. So one does not give you the right or the ability to do the other.
Okay, so to what extent should developers and deployers be held responsible for memorization if specific infringing outputs are triggered in response to users' prompts?
I think that we start to see more and more AI developers that are seeking licenses, although those licenses are not necessarily in relation to training, but for post-training activities such as RAG, right? retrieval augmented generation. I, I think that when you have, but that is my personal view. I think that if you are an AI developer and you do work under a license scheme, and once you have a license, you can also say openly, my output are also being verified live by reference to various sources of information. You would see that some of the models today actually give you a reference, if not a link, to the information which was used in order to verify in real time the output. This not only helps them to put aside some concerns in relation to licensing and infringement, but it also enhances the credibility of the model output. A lot of us out there, when we do use AI models, are worried about hallucinations and about including every second day we have some a funny story about this professional or that professional using AI in their line of work and then getting some ridiculous results for which they sometimes suffer some consequences. I think that when you do have a license, when you do work on the basis of a license structures, and you do have a RAG a type of arrangement, you are likely to attract more people to come and use your model because it comes across as more credible. So I personally think that licensing or permission, either as a blanket license with some collective arrangement or something which is mandated by law, is the key for the future. This will settle in one way or another when permission would need to be granted and in return to some type of compensation model.
Well, we have more than a dozen questions that have not been covered, but one last one. I hope that won't be too long because we're about to close in 2 minutes. So in your opinion, would AI outputs be adequately protected by a newly created neighboring right instead of copyright as claimed in ongoing discussions?
That is an interesting one, which is a little bit outside the topic of our, but some of the people here may know that there was a decision again from Munich in the 13th of February, on the 13th, I think, of February. So that was last week. And that is a decision that touched upon this point precisely. And that had to do with, I think, the generation of 3 logos where AI tools were used for generating them. And in all instances, in all those 3 instances, the court held that there was no copyright. No copyright existed in relation to each of those works because the AI tools were used in such a way where no human authorship could be identified. So ultimately, the question, and I'll try to answer it very, very quickly, is the fact that you used AI tools to generate work does not on its own decisive and will not be decisive in finding that there is no copyright protection. It's the quality of the human contribution to the process. And the fact that you prompted also should not be decisive in finding against you, the human actor here. It's the nature of your prompts and what did you do post-prompting. If the prompts were suggestive or the prompts were more instructive, and that's, I think, the most that I can say now within our time constraints. Right? It's a fascinating area, and I mean, when was it? Last week, I gave, I think, 2 hours lecture only on that topic. So, a fascinating area.
Thank you so much. Because every time you come, we know at PIP we really love having you. You sharing your knowledge, and considering the number of questions we have received today, maybe that would be worth it to have a follow-up webinar in the future. So thank you all also for submitting your questions and for attending this webinar. That's really appreciated.
Thank you, everyone.
The presentation will be made available soon, I think tomorrow, the recording as well. So do not hesitate to listen again and again to let us know if you have any feedback. And don't forget, please, to follow us on X, LinkedIn, YouTube, and Instagram. Our handle is always the same for IP Council. And you can find everything about IP news, resources, legal news, and the future webinars. Finally, tomorrow, you will receive one email just to provide your feedback if you have any topics you would like to be covered by for IP Council in the future. Your feedback is very important to us, so we would be very grateful if you can just take 1 minute to answer it. Noam, really a pleasure. Thank you so much for participating again.
Pleasure.
And we are looking forward to your new course, the new LM that you are just opening.
Thank you.
Thank you all.
Bye, everyone. Thank you.
Bye.